Okay, well, sounds like we're live and we can get started here. Today is Wednesday, November 10th. The time is 10:02 a.m. This is the time and place for a workshop for the Cannabis Compliance Board. This meeting has been noticed in accordance with the open meeting law. We do not need to take roll officially today, but I will note for the record that we have members Merritt, member Durrett, and Chairman Michael Douglas from the Cannabis Compliance Board joining us today. Before we get started, I would just like to clarify a couple things on what we're focused on today, and that is on diversity certification. That is the topic that we're discussing today. That's what the proposed regulations that we're workshopping today are around. The Cannabis Compliance Board is required by law, NRS 678B-280, to consider diversity on the basis of race, ethnicity, or gender during any application and licensing process. And so what is being workshopped today are regulations that would provide for a third-party certification on diversity for a minority-owned business or a woman-owned business. This is something that's used by the state of Nevada and other organizations across the nation. And the reason we are workshopping this today is because if we are to use diversity certification as part of the lounge license process, we need to get these on the books in short order to allow individuals time to utilize the certification process as part of that. What's important here is I want to clarify this is not social equity. This is not the social equity applicant process. The definition of a social equity applicant is something that is still being worked on as part of the regulations for consumption lounges. It'll something that will be workshopped at future workshops by the board. And so before we go into public comment, I just wanted to make that distinction that what we're talking about here today is diversity certification, not social equity applicants or social equity certification. So with that, and before we move into public comment, Chair, if you wanted to add anything to the record, or we can just move on to public comment.
Let's go ahead and move on. You covered the point very well that needed to be made as a distinction between what this is doing and social equity.
Okay, great. So with that, we'll move to the agenda item number 1, which is public comment. Ms. Verkler, if you could please run the public comment portion and facilitate any public comment that is up for today, please.
Thank you. For attendees on the telephone, please press *9 to raise your hand if you would like to provide public comment. For attendees that have joined via the Zoom app, please use the controls at the bottom of the screen to raise your hand if you would like to provide public comment. I see no hands raised.
Okay, great. And we will move on. And if we do receive any public comment through email, either before the meeting or during the meeting, we will obviously post that online for the public. So now we'll move on to agenda item number 2. These are the proposed amendments and additions. I will turn it over to Deputy Director Michael Miles. I believe he's going to take all of them at once and open it up for questions. So Deputy Miles, when you're ready.
Good morning. For the record, my name is Michael Miles, and I'm the Deputy Director of the Cannabis Compliance Board. I'm going to go through the proposed changes to the regulations which governs the diversity certification component of the licensing process. The diversity regulations discussed today are separate and distinct from the social equity changes, as Director Klimas discussed, which are currently being promulgated and will be part of a later public workshop tentatively planned to be held in December. To clarify the difference, a social equity applicant means an applicant who has been adversely affected by provisions of previous laws which criminalize activity relating to cannabis, while diversity is considered as a criteria for applicants based on race, ethnicity, gender, and for medical establishments, veteran status. We will open the forum for public comment after a description of the changes within the regulations. After the public comment, and if there are questions by the board members, CCB staff is here to respond to these questions. Starting with Regulation 1. There are 2 proposed additions to Regulation 1, which is the definition section. NCCR 1.082 is being added to define a diversity applicant, and NCCR 1.083 is being added to define a diversity certifying entity. As all three of these regulation changes and additions are all closely related, I'm going to hold off on public comment until I go through all three. Regulation 4. Okay, now Regulation 4 governs discipline and disciplinary proceedings. The changes to Reg 4 add violations and penalties to various category violations. Specifically to address the requirement of complete honesty for an applicant's dealings with a diversity certifying entity. NCCR 4.035 adds that intentionally destroying or concealing evidence from the board agents, and/or a diversity certifying entity, as well as intentionally providing false and/or misleading and/or incomplete information and/or all documents to a diversity certifying entity are a Category 1 violation. NCCR 4.040 adds that unintentionally destroying or concealing evidence from the board agents, and/or a diversity certifying entity, as well as unintentionally providing false and/or misleading and/or incomplete information and/or documents to a diversity certifying entity are Category 2 violations. On to Regulation 5. This covers licensing of cannabis establishments and specifically deals with how diversity certification is accomplished. NCCR 5.045 is being updated to require certification to qualify as a diversity applicant. The update requires certification from a third-party diversity certifying entity on the basis of race and/or ethnicity, gender, or veteran status for an applicant to qualify as a diversity applicant. Third-party organizations are identified that will provide certification as a diversity applicant in one or more of the following categories: woman-owned businesses, minority-owned business, and/or veteran-owned business, which pertains to medical cannabis establishments only. Previously, the regs stated that the board will promulgate regulations on the ranking of the applications. This update removes the subjectivity involved with ranking and clarifies the process for consideration as a diversity applicant. Now we will open to public comment. Amber, do we have any public comment on these three regulation changes and additions?
You know what, I'm just going to jump in real quick. Do we want to do any questions from board members first before we open it up for public comment?
We can. We usually did public comment first and then questions from the board, but.
Chair, do you have a preference?
Let's find out if the board has any general questions first, which might clarify some things before we go forward.
I have two questions. The first is, I thought I understood the diversity versus social equity, but just to make sure, with the diversity definition, this is going to apply to any licensing going forward, right? And so we don't know exactly how much weight is going to be put on diversity yet. If we don't know if it's going to be a ranking system, we don't know yet. We don't have those regulations promulgated. So right now we're just defining it so people can go ahead and obtain the certification, but we don't know how much it will weigh into any licensing going forward. And it does apply to all licensing. Is that all correct?
That is correct.
No, I was going to say, how much do we go into it? I mean,
That is correct. And so, you know, the first step here, right, is to make sure we know what counts as a diversity applicant, right? And that's why we're going to propose to use the certifying bodies. Something that we can consider, or the board can consider moving forward, is a certain percentage, right? Which is utilized, you know, kind of with other contracts, government contracts, and even contracts outside of government contracts. So the board could consider a percentage if it wanted to during those discussions, like, you know, 30% per se of licenses should be issued to diversity applicants. But you're correct, Member Durrett, that would be a next step after what we're discussing today.
And then I know you identified certain organizations that do these certifications. When I've looked into these in the past, it seemed like it was kind of an arduous process and it might be expensive. Have you looked into what they do require to be able to get certification?
Sure.
Like fees and the timeline. Yeah.
Yeah, so thank you for the question. So we're going to have Jane Maurer from our office talk a little bit about the organizations and the fee structures as well. So Jane, when you're ready.
Good morning, and thank you for your question, Member Durrett. The fee structure for certification varies depending on the certifying entity. To certify a business with under 1 million in annual gross revenue, the fee ranges from $350 to $400. The highest fee charged is $1,250, charged by one certifying entity for businesses with greater than 50 million in annual gross revenue.
Great. And do you know, have you checked out about how long it could take?
Absolutely. All three organizations do state that it can take up to 90 days, but in conversations with all three organizations, they've indicated that it's basically between 30 to 45 days, and the amount of time really depends on if a complete application is submitted.
Thanks.
You're welcome.
Do we have any other questions from members of the board on?
No, let's go ahead and open it up.
Okay, Amber, if you could facilitate any public comment that is online.
Okay, once again, for attendees on the telephone, please press *9 to raise your hand if you would like to provide public comment. For attendees on the Zoom app, please use the controls at the bottom of the screen to raise your hand if you would like to provide public comment. Okay, I have one phone-in listener. Caller,
Great, and for the-
dial *6 to unmute, and you may state your name for the record and begin.
Repeat it.
I believe you're muted, so if you could unmute your phone and state your name for the record, please.
Dial *6 to unmute.
There we go.
Okay, hi. I'm sorry about the technical issues there. Hi, my name is Timothy Eliado. I'm representing Chemovario. And for the records for public comment, I wanted to state that I'm still very disappointed in the fact that we have that the council feel it's necessarily to basically to put out I guess the idea that minorities or people of color, are not able to be maybe the key terms business savvy enough to be able to basically run an MME operation. And I just wanted to state that you're speaking to one of hopefully to be an applicant who helped a lot of these MMEs start right from the very get-go. Whether it was consulting on any parts of any parts within the supply chain to basically build out to everything that basically is connected to the industry. What I'm saying is that in most states, what we really needed was some sort of access to equity, just like how they were able to basically form MSOs overnight once they were given a chance or got a license. They were able to bring the financial aspects into their operation, in which we are being denied that same opportunity. So all I'm stating is that putting together, it reminds me of what the Department of Taxation pretty much did a few years back. The CCB is pretty much heading towards the same direction, which I mean is corruption. Look at everyone that is currently on the board. You have lobbyists that you have placed on the CCB, board, who does not come into the community, has any meetings, doesn't feel the need to even contact people within the community, who has been doing this way longer than she has and been involved with. I really think that this whole issue really needs to be readdressed. We need to go back to the drawing board. We have a lot of issues that needs to be discussed. A lot of the definitions, all those criteria that were picked, a lot of people that this is affected are not going to be able to fit within those criteria to even be able to apply. And I think that this is very unjust, and it's really, really, really sad to see that some of the really good prospects are not going to be able to be part of this industry. As I'm speaking, I have cultivars that I have been working on for several times. It's not going to be inducted into the Texas A&M research program, in which we'll also in tune we'll go into the Scottsdale Research Institute, which is headed by Dr. Sue Sisley, who has been awarded the only federal cultivation license in terms of research. These are the kind of people that you're keeping away from the industry. People like me who have a lot to contribute to the industry moving forward just because of our skin color, and then with pretty much not having access to capital, you stating that we cannot get help. But the point is that if we do get these licenses, we are liable to raise funds and be able to basically sustain and have a sustainable industry. So that's my point. Thank you.
Thank you. Do we have any other public comment?
I see no other hands raised at this time.
Okay. Chair, do you or any members of the board have any additional comments or questions on the regulations being workshopped today? The proposed regulations.
The Chair Douglas, for the record, the regulations that have been put forth today, as you indicated, are not social equity. They're diversity, so we can tally diversity. In certain cases, we can allow certain kind of additional allowance for diversity. This also takes, based on the last comment, takes the board and staff out of the certification process. You have an independent third party who does not grant or deny licenses, making that distinction. It's submitted to the board, subject to possibly an objection to be checked off that they meet those criteria. To date, social equity has not been defined, nor its use has not been clarified. That's still in the works. And we're waiting for the reports from the advisory commission, which are recommendations at this point, which we don't have to accept, can use, can go into more depth. So we're in the process of trying to move forward in this process. Social equity, as the last person who spoke talked about, was designed to get a greater portion of the community in. But there's a whole lot of other things to take into consideration within what his comments were about. Right now, social equity is the first opportunity to use it is as to the lounges and as put forth. And the legislation for lounges is very specific, who are going to be licensed initially, leaving open the question of what regulations are going to be promulgated for the equity-based lounges. That's it. Any other board member wish to make any comments? And I used equity instead of diversity, I'm sorry.
Okay. Thank you, Chair. If there's no other questions from board members, we can move on to agenda item number 3, which is general public comment. Ms. Verkler, when you're ready, please.
If you would like to provide public comment on the telephone, please press *9 to raise your hand. If you have joined via the Zoom app, please use the controls at the bottom of your screen to raise your hand. I see no hands raised to provide public comment.
Thank you. Well, then with that, we can move on to agenda item number 4, which is adjournment. Chair, members of the board, thank you for joining us this morning. Members of the public, thank you for listening in, and commenters, thank you for your comments.